request Mr. Anil Divan to preside over the session.
Friends, this is the second session on the same topic, a very vast topic, but in India, for the moment, we are concerned with a constitutional amendment by which the old collegium system is being altered and a new system with a National Judicial Commission is being substituted. I think I have written a few articles on this, so my views are reflected in that article, and you can have a look at them. This is in relation to the amendment of the Constitution. And on a lighter vein, let me tell you how, when I went to Fiji many years back, as President of Lawasia, I had submitted a paper and I told them about various Supreme Court judgments on Article 21, and I had reproduced Article 21. So the Fiji Law Society, Fiji is a very small country, they said, no, we'll print it overnight and distribute your article tomorrow, which they did very rapidly. Unfortunately, there was an error, and when they reproduced Article 21, it read like this. The correct article in our Constitution is, no person will be deprived of his life or personal liberty except in accordance with procedure established by law. What came out in the Fiji Law Society was, no person will be deprived of his wife or personal liberty except in accordance with procedure established by law. So I intervened and said, look here, our constituent amendments take a lot of time, but Fiji Law Society overnight has amended the Indian Constitution. But I also raised my voice of protest, that why did you include only wife and not a husband? Isn't that gender discrimination? To which Mr. Lala, he was of Indian origin, I still remember him, Mr. Lala, President of the Fiji Law Society, he said, whether we have committed discrimination or not, all Indian wives will appreciate our amendment to the Constitution. So that is the rule of law by amendment. Now friends, you've got a lot of viewpoints on this, etc., etc. I don't want to trouble you with my views or burden you with my views, but I'll say a couple of things for the young students and the young lawyers who are here, and a couple of things on advocacy. They say, if you're a litigator, what is good advocacy? It is said that out of 100 cases, 90 either win themselves or lose themselves. Advocates are irrelevant because the merits of the case, the judge will decide it one way or the other. 3 cases are won by good advocacy, and 7 cases are lost by bad advocacy. And one of our greatest advocates, with whom our friend Shankardass devilled, was C K Daftari. And a story about his advocacy, there's so many stories, but one I'll share with you. He had gone abroad when he was Attorney General to the International Court. I think it was Run of Kutch case or something, and he came back after a break. And then he was arguing a special leave petition before a bench presided over by Justice Hidayatullah. So Hidayatullah started by saying, Mr. Daftari, there is very little substance in your special leave petition, except that you are appearing before us after a very long time. Now, Daftari was very quick, a great advocate. He said, my lords, why not celebrate the occasion by admitting it? So Hidayatullah laughed and said, admitted. Now look at the timing, look at the psychology. He was a great psychologist, etc. Another story of his, which I must share with you. I was a student in the Law College, Bombay, and the second prohibition case was going on. And the second prohibition case, it was 47 or 48 or 49, something like that. And the petitioners were represented by Sir N.P. Engineer, who was the former Advocate General of India before the Constitution came. Then Settlebat came as Attorney General. So he was leading the charge. Nani Palkhiwala was a mere junior at that time, nothing very. And on the other side was Daftari and Sirvai. Sirvai was not Advocate General, Daftari was the Advocate General. And then Chagla delivered. The bench was a very powerful bench. Chief Justice Chagla, Justice P.B. Gajendra Gadkar on one side, and Justice S.R. Tendolkar on the other side. Their portraits are there in the Bombay High Court. And then Chagla delivered a judgment. And he struck down two rules which prohibited the distribution and sale of two products. One was called Eau de Cologne, colon water, Eau de Cologne, which had some spirits. So that rule was struck down. And another was a medicinal preparation called Holzwein. That was also struck down. Because they said, no, this is a medicinal preparation, you can't prohibit it. This is a toilet preparation, you can't do it. So Sir N.P. Engineer argued with authorities that I have succeeded in getting two rules invalidated. Therefore, I should get costs, if not full costs, at least a substantial costs from the government. I have succeeded. So Daftari, it was an argument for half an hour or so, citation of authorities, etc. Sirvai was next sitting to Daftari and telling him, you answer this, you answer that. Daftari ignored him. Daftari got up to reply. And he said, my lords, I am not going to answer all these authorities, but I am only going to make a very short submission. And that is this. My learned friend wanted to strike down the Prohibition Act. He wanted a bottle of Scotch whiskey. You have only given him a bottle of toilet preparation. How can he get costs? So both Chagla and Tendulkar, who enjoyed an evening drink, said, yes, no costs. Only one sentence, just see the man's advocate. Only one sentence. If you have come for a bottle of Scotch whiskey and you get a bottle of toilet preparation, eau de cologne, how can you get costs? So that's advocacy. And I think the next session after this is on young lawyers and their skills. So to develop a skill on advocacy is a very important skill which you must all try to develop. Now with that little introduction which has nothing to do with independence of the judiciary, I will now call upon our friend Upul Jayasuriya, President Bar Association of Sri Lanka. I know him since many years. As I mentioned in the morning, he was a councillor or alternate councillor of LODHA when I was president of LODHA as far back as 1992 to 1993. But apart from that, he bears a name which is familiar to all cricket lovers in India, Jayasuriya. Who doesn't know Sanath Jayasuriya? He completely revolutionized the one-day cricket game as well as T20. So with this, I have requested him, because Sri Lanka has gone through a major crisis last year, 2013, where their Chief Justice was removed. So I have said, please share with us your experience, what happened, and educate us on what happened as far as that controversy is concerned. With this, may I request you, Upul?
President, BAI Association of India, Mr. Anil Divan, and all the distinguished ladies and gentlemen at the head table, and the members of the legal fraternity. The legal profession in Sri Lanka faces tremendous challenges which are linked especially to threats to the independence of the judiciary, which is the very foundation of our profession and democracy in our country. The strength of the bench and the strength of the bar are both closely linked because the rule of law requires that they complement each other. The bond between the independence of the judiciary and the independence of our profession is so deep that we may call ourselves twins. Indeed, we stand or fall together. In my own jurisdiction, phrases such as the independence of judiciary and the rule of law may sometimes invoke cynical smiles rather than cheers. Yet, may I crave your indulgence to briefly explain why I think these phrases are of fundamental importance to the legal fraternity, the bar, particularly to our country at this important time in our history. Confidence in the administration of justice depends upon the public recognizing that judges act according to law and are free of pressure or interference that impact on their role and responsibility. If this confidence evaporates, so does public respect for judiciary. To endeavor to maintain public confidence in the administration of justice is a grave responsibility that rests on judges themselves as much as on those in power. As we have seen to the detriment of the judiciary since 1996, with the swearing of the Chief Justice then Sarath and Silva, we have not moved forward. Threats to the good name of the judiciary can emanate from within the judicial ranks as well as from outside. These are questions that have become peculiarly important to us at this time in Sri Lanka, perhaps more so than at any other time of the Sri Lankan bar. The doomsday of the rule of law and the independence of judiciary in my country was not too long ago. The events that led to the diabolical fate is remembered by all lawyers regardless of their personal prejudices and political affiliations. I've been invited to refer to this background in a synopsis. The presidential election that was held in Sri Lanka 2010 was contested by General Sarath Fonseca, who spearheaded the guerrilla war, and he contested the incumbent president, Rajapaksa. He was imprisoned and sentenced to jail by a military court soon after the elections on trumped-up charges. Whilst in jail, CJ 43rd, the Shirani Bandaranaike transferred General Fonseca from a government hospital to a private hospital where the facilities were better. This order upset the powers that be very much. 1 week after the said order, his bail matter was due to be taken up before the Supreme Court on other offences, as the jail term was already concluded. Realizing the high probability of the general being released on bail, the Supreme Court bench presided by the 43rd Chief Justice, Parinder Rana Singh, President Rajapaksa hurriedly granted a remission of the sentence, releasing General Fonseca. Simultaneously, state-sponsored unions and other sponsored goons started agitating against the chairman of the National Savings Bank, whose chairman was Dr. Bandaranaike's husband. An important bill that decided the fate of nearly US dollars 80 billion came up in the Supreme Court to decide its constitutionality of its control being vested in the minister, who is the brother of the president. Was determined by the Supreme Court that certain provisions were unconstitutional. Other directors of the NSB resigned, and the president visited the working director, who was his personal astrologer, at his residence and congratulated him for his resignation. A few days later, the signatures were collected on blank sheets of paper, allegedly for an impeachment motion against the 43rd Chief Justice. The prime mover member of Parliament was quoted in the most popular daily newspaper, Daily Mirror, that the impeachment was originated based on the ruling of the SC determination on the bill. There was no contradiction by the MP concerned. During this period, the Bar Association General Meeting, moved by me before I became the president of the Bar Association, was attended by nearly 3,000 lawyers from all over the country. It was historical. We urged the President, we resolved the President to reconsider the impeachment and also to allow the BSL to observe the proceedings of the Parliamentary Select Committee. The Court of Appeal in a writ application referred to the Supreme Court seeking a determination on the powers of the Parliament to interfere with the proceedings of the Parliamentary Select Committee on the impeachment of the 43rd Chief Justice. The Supreme Court held with the Chief Justice Bandaranaike and directed that the Court of Appeal has a power to issue a writ on the Parliamentary Select Committee. There were 7 Parliamentary Select Committee members appointed by the government and 4 appointed by the opposition. CJ Bandaranaike asked for time to examine the bundle of paper, more than 1,000 pages that were thrust on her the previous day, and this application was rejected. In disgust, in the same time, certain members of the Select Committee appointed by the government ruling party were using abusive language on her at the Select Committee. In disgust, she walked away from the Select Committee, and 4 members of the opposition too walked away in disgust. On the next day of the inquiry, matter was taken up by the 43rd Chief Justice that she asked for an opportunity to cross-examine the witnesses. She was told, and her lawyers were told, that this proceedings was going to be held based only on submissions and documents, and there will be no witnesses that would be called to give evidence. This application was refused anyway for a further postponement. Half an hour after she walked away and the opposition members walked away from the Select Committee, 16 witnesses walked in, led by a senior-most judge of the Supreme Court, Justice Tilakawardena. Witnesses were led till 12 midnight. There was no cross-examination, as the other party has moved away on the statement that was said by the chairman of the Select Committee, stating that they will not be given an opportunity to cross-examine the witnesses. In the meantime, the Court of Appeal, a divisional bench presided over by the then President of the Court of Appeal, Justice Sriskanta Raja, and 2 other judges, issued a writ against the Select Committee. Before that, what happened was, the next day morning, this particular day, the proceedings went on till 12 midnight, and the next day morning, 35-page long report was ready by 8 a.m. in the morning. And this was quashed by the divisional bench by the issuance of a writ by the Court of Appeal. In the meantime,